Morning light through the blinds creeping, eyes on the clock while the world keeps sleeping. Coffee cold as my nerves keep twitching. Long crime will soon be switching. On and on are all the eyes on the live stream. Just my need to switch it to trial TV. Sarah Boone's in the camera's glare. Suitcase secrets creeping through the air. All she cares about is her suit and jailhouse hair. A bag of letters and made-up face. I'll save a smile from any grace. When the jury finally comes to see, she deserves craft singles and a first degree. Ooh, I'm waiting for truth to unfold. Every whisper, every word so bold. Waiting for Carrie to switch on the feed. Grabbing the Pop-Tarts and getting ready. Fingers crossed, the stream stays steady. My thoughts tangle, it feels so heavy. Will the testimony be true and pure? I'm on edge and I can't be totally sure. Rightful truth, courtroom drama unmasking proof. The defense getting credit and giving us hope that the jury sees Boone trying them for dopes. Sarah's guilt is plain for all to see. Intentional for Suitcase, second degree. Justice for George amidst the misery. Lost patience tried and attention's weighed. Verdict coming, but we must wait. Echoes of doubt make my heart beat wild. I just need the facts untouched and mild. YouTube's glowing, don't let me down. In this court we'll see who wears the crown. I'm waiting for truth to unfold. Every whisper, every word so bold. Waiting for Carrie to switch on the feed. Grabbing the Pop-Tarts and getting ready. Fingers crossed, the stream stays steady. My thoughts tangle, it feels so heavy. Will the testimony be true and pure? I'm on edge and I can't be catch it totally sure. Ooh, I'm waiting for truth to unfold. Every whisper, every word so bold. Waiting for Carrie to switch on my feet. Grabbing the Pop-Tarts and getting ready. Fingers crossed, the stream stays steady. My thoughts tangle, they feel so heavy. Will the testimony be true and pure? I'm on edge and I can't take much more.
Well, hello everyone. Welcome in. It's been a bit since we've talked about the infamous Suitcase Sarah Boone, but today we must report on some news. Crazy Sarah and her overzealous attorney have decided that they're going to file a motion for a new trial. I said that too loud. I apologize. My word in heaven. Okay, let's read this together. Y'all try not to laugh while I'm reading. Oh, it's okay. You can laugh. I won't be able to hear you. Okay. Comes now the defendant, Sarah Boone, by and through counsel, and pursuant to Rule 3.600, Florida Rules of Criminal Procedure, files this motion for new trial, stating in support thereof the following. Number 1. The defendant was found guilty as charged of second-degree murder on October the 25th of 2024. And we were there, and we were loving every moment of it. Okay, number 2, the instant motion is timely filed pursuant to Rule 3.600. And number 3, the defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. The court erred in ruling that the defendant was not entitled to court-appointed counsel. Oh, I knew that was coming. Doesn't matter. You still got your own counsel. The court erred in denying undersigned counsel's multiple motions for continuance. I mean, you know what? Here's the thing. You knew what you were getting into. He knew he was going to do this, you guys. He knew he was going to do this. And I don't know, maybe he didn't know he was going to do it. Maybe she's forcing him to do it. The court erred in ruling that the defendant was not entitled to court-appointed counsel. The court erred in denying unsigned counsel's multiple motions for continuance, and the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. Number 4, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. And finally, 5, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Really? Okay. Going after Mr. J, are you now? Oh, this is just okay. I want to know who rules on this. You're wanting to go over the judge's head on this one, right? So I don't think Cranick can rule on this, right? Am I right? I don't know. How does this work? Somebody tell me. Argument 1. In the above styled and numbered case, the defendant has approximately 7 court appointed attorneys prior to the undersigned counsel taking her case. She should, all because of herself, all because of what she did, all because of the way she acted. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to represent her at trial. Well, the above case was very complex, even for a seasoned trial. Of course, she's going to say that. Even for a seasoned trial attorney who was the public defender of the first use. Of course, he's going to throw out his own thing. Okay, the above case was very complex, even for a seasoned trial attorney who was the public defender of the first judicial circuit for years, as well as having a thriving private practice. It was thriving so much that he could close it down all to take on Sarah's case for free. So he says. Okay. It was apparent to undersigned trial counsel that Miss Boone would be grossly ill prepared and unequipped to handle a trial of this matter. Not our problem. I'm sorry, I need to stop putting in these little things. Y'all might think I'm reading it. Or, in fact, to handle any other phase of the trial without counsel. Well, she did it to herself. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. See Bowden versus State and State versus Kelly and progeny. There appear to be 2 exceptions to this precedence. If the defendant physically harms or threatens to harm his or her counsel. If the trial court certifies that the defendant will not be incarcerated if found guilty, i.e., a judge trial. Should the court determine that the defendant is not entitled, that's not true, i.e., a judge trial. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's rights to due process, as well as the defendant's right to the assistance of counsel. In the instance case, you know what, y'all? I don't think Jamie read those letters, you guys. I don't think he did. In the instant case, undersigned trial counsel would assert that Miss Boone's behavior did not rise to the level of misconduct. Really? To warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior. No, they did not. No, they did not fail that. No, nope. I sound like Daryl Brooks. Nope, not gonna listen. Not listening to you anymore. The court failed to warn her or inform her that the continued misbehavior would result in a failure of the right to court-appointed counsel. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for new trial being granted. Under controlling precedents, Rule 3.111, Florida Rules of Criminal Procedure, and the Sixth Amendment, the defendant through counsel moves the court for a new trial. I'll see something really quick. Oh, he did put a certificate of service. Okay, I was just double checking, because you know how he is. Margaret, she got that certificate on there. Margaret did that. Okay, so whatever. I think that's crap because not only did Cranick do it, remind him, The other judge, the judge starts with W. The other judge reminded her. I could see his face and I can't think of his name. It's on the tip of my tongue. Anyway, he reminded her too. And I think on multiple occasions, actually, they reminded her. So, yeah, Argument number 2. The court shall not deprive a defendant of his or her right to counsel of their own choice. Excuse you? Oh, okay. So failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for a continuance by new counsel. Okay, so that's crap because this case has been sitting here for 4.5 years, and I've watched trials where, okay, the Farrader trial. I remember they had, wasn't it Farrader? There was a trial I was watching not too long ago where a new counselor came in and they wanted to extend the trial date. And the judge was not happy about it. He's like, we've been waiting on this, I'm booked up, this and that. It was just a huge inconvenience to everybody involved, right? Because they had to keep they had to reschedule it. Now they did it, but it wasn't 4.5 years and 9 attorneys later. You know what I mean? It was just one of those things where it was like, okay, he worked with them on it. But this was getting ridiculous. I mean, so you file a continuance. And what would have happened? Would James Owens and Sarah had time to get into another argument and then he would have bounced on her too? Because that's probably what would have happened if he'd had more time to work on this case. All right. So anyway, he's saying that see Perozzo versus State, see McKenzie versus State, and Jones versus State, and Deal versus State. In the instance when the undersigned counsel, okay, you know what? I want to look at all 4 of these. And I want to know, do any of these reference 4.5 years of a problem defendant who has already gone through 8 court-appointed attorneys? In the instant case, when undersigned counsel came on board, the case was 4 years old. No, actually, Jamie, it was 4 years plus. Undersigned counsel filed his notice of appearance on August the 30th of 2024. Okay, yeah. So it was 4 years and 5 months when he came on board. This gave counsel 45 days to prepare for a second-degree murder trial. Well, the judge told you, should we replay? We should replay it. Yep. Let's watch back and see what Jamie says when he's told he's not going to be given a continuance.
Thank you. All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. But it is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torrez in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a better spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim, and I would respectfully ask. I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without a better spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist that makes that claim. I just can't say, hey, I'm going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brandon needs more time.
All right, thank you. State, anything else?
No.
All right, thank you very much. All right, Mr. Rose, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyer basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in a judge portion, that trial specially set for October 7th. 2024, and that would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023 again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and had the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwoods, Thompson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations at various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311, 7, 3rd, 185, and 189, Florida 2nd PCA 2020, your motion for continuance is denied. This trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have full practice. I've got a docket day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're originals. I'm going to need to look at that. I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State?
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Give me a moment. On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence. Tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall follow a court notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, the pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Terry?
Give me 1 minute.
Sure. State, anything else?
Not this time, Your Honor.
Madam Clerk, going to work dutifully to, it's already done? Excellent. I'll ask Ms. Barrios My judicial assistant forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare. He did his best, Judge. He did his best. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Miss Boone and attending multiple hearings. This is ridiculous. Who do these people think they are? Oh my God, I have never in my life. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records of prior contact of Miss Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Miss Boone being the aggressor at times. Okay, well, I mean, it already happened and it was ruled on and it is what it is. Counsel, for all purposes, closed his law practice down to prepare for trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be. And Miss Boone was entitled to. Under the controlling case cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. No. You knew what you were getting into. You chose to take it. It is what it is. Sit down, Owens. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Oh, okay. So they're not allowed to get upset about the fact that she killed his son. Now, remember, I can say that now because, hello, she's been convicted. Undersigned counsel timely moved for a mistrial, requesting a new trial. Yes, we remember when you threw a fit in the courtroom, James. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. He did move on pretty quickly on that, I will say that, but I felt like, I mean, no one has control over that. There's nothing you could do about that. I've seen it happen a ton of times that somebody gets upset and then the jury sees it. There's nothing you can do about that. Yeah, appeal it. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. Then appeal it, boo. Appeal it. Take it over to the appellate court. The court is unable to determine if this outburst affected the jury's decision because no injury was made. Under controlling precedents, the defendant is entitled to a new trial. You were unable to determine if the outburst affected the jury's decision. Well, there was a lot of things we were wondering if it affected the jury's decision, but when you come back in an hour and 25 minutes with a guilty verdict, and here's the thing, y'all. They probably said we don't need to leave, and we can fill that paperwork out right here in the jury box. We don't need to go back there. I just looked at the guy next to me. We were like, this is a no-brainer. Let's roll. Let's do this. Oh, wow. Okay. I mean, I will say this. James Owens, he tried. He did his best. He did the best he could, Judge. Argument number 4. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner. Yeah, we knew all this was coming, but so this part right here, it irritates the hell out of me because it took, it's not almost a whole day that we spent on this crap with him, going back and forth with this witness. It says that after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness's deposition taken on October 4th of 2024. Oh, you mean that deposition where she said you didn't ask the right question? You didn't ask her? Where you said that deposition. Oh, I know what deposition you're talking about. You're talking about that one where she said, well, you didn't ask me. Oh, yeah. The state committed prosecutorial misconduct by failing to disclose his new opinion as agreed, or this new opinion as agreed in the deposition mentioned above. Okay, whatever, Jamie. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. Bah. The state's expert, Dr. Tanya Werner, MD, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Okay, well, there's not a whole lot of threat going on there when he's in a suitcase and he can't get out. To say that she was going to let him out of the suitcase and then he was going to come after her afterwards, I think all of that has been thrown out the window when you look at, oh, y'all, I have a new cat. I didn't want another cat. I have a blind cat. And now I have another cat. And his name, I haven't named him yet. And he's like a little baby. He's so needy and clingy. I'm not used to this. He wants to be up in my face all the time. I can't have that. So we're having to learn each other's personalities a little bit here. Okay. I'll tell you the story about how I found him, where I found him another time. People want to listen to this. We'll talk about it another time. Okay. See, here's the problem I have with this. As I was saying, it doesn't matter. None of that matters, because when you look at what goes back to the jury, if you were to sit here and poll the jury right now and say, if you had heard this or that, or if you knew this or that, would it have mattered? I guarantee you they all would have said no, it doesn't matter. Oh God, I would love to hear from one of those jurors. I would love to hear from one of those jurors. I mean, obviously they didn't spend a whole lot of time deliberating and getting to know one another, but I don't know. I feel like one of them could say, yeah, I mean, it was the video. Was it the video of him in the suitcase, or was it the video? See, to me, I think it was a combination of him in the suitcase added on with all those videos we saw of how she talked to him, how she treated him. She's a complete crazy lunatic, and the jury saw that, and she convicted herself, and there's no way around it. James Owens could have bribed the entire jury, and they still would have found her guilty. I mean, it's that bad. You know what I mean? Okay. So anyway, moving on. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusion when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. I don't know what he's talking about. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Well, Section 90703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. All right, and then finally, argument 5. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. Wherefore, premises considered, the defendant seeks the relief sought herein, as well as any other relief to which she may be entitled. The defendant requests a hearing in this matter. Okay, so here's my thing. He did give case law in the other pieces. He didn't give case law in this last piece, so that's probably just a jab at Jay. I don't think this is going to go anywhere. I'm wondering if it goes over to another judge. Remember the judge that looked at the whole stuff for the JAC with Cashman, well, it's Cashman, Hobson, and Frank. I think she might look at it. I don't know. I just don't see how. I guess they're going to have a hearing. Would they have a hearing with Cranick first? Or does this automatically go outside of over Cranick's head? I don't know. I just feel like I don't know if I've ever seen this before. I mean, I've heard, we knew she was going to file an appeal. Everybody does that, right? But again, I think this is just a Hail Mary. I don't think it's going to amount to anything. And again, I'm not an attorney. Y'all know that. So my 2 cents is this a bunch of crap? But I am now going to be pulling up the docket. We've got a month before her hearing. It's on the 2nd of December for her sentencing. So I don't know if he's going to set another hearing. He might say, we'll discuss it before the hearing, before the sentencing. I don't know. I just feel like Sarah's gotten enough of time in the limelight, and it's time to move on. You had your shot. You kept pissing everybody off. The things that she would say. And you know what the beautiful part of this is, guys? It's not just that, it's not hearsay. It's not, she said this about me, or she did this, or she did that, and that's why I wanted out. She wrote letters to the court system, to the judge, and to her attorneys. It's all in writing. So once again, what's going to bite Sarah in the ass on this is going to be her own doing. And I'm here for it. I love it. Let me grab my popcorn, or in my case, some almonds, and a Diet Coke, and let's just sit and watch this play out. I'll keep an eye out on the docket, and if they have another hearing set up, I will definitely let you guys know about it. In the meantime, if you haven't already, go vote today. It's an important day here in the United States. It's the one time that we can actually have a voice. One of the few times in your life that you can have a voice. So go have your voice. And tonight's going to be nothing but election coverage. So I'm thinking that I probably won't go live. I was thinking about it, and then I went, wait, no, it's nice. No, we'll wait. Tomorrow night, what I'd like to do is we'll get together and we'll talk about this Corey Richens hearing where they discussed her financial stuff, because I watched it today and I started doing some editing on that. And that is very, very interesting. Now, that will probably be a live stream tomorrow night. And then I'm going to have another live stream as per y'all's request on Sunday evening. So I'll get those live streams set up so you have plenty of time. You now know about it. You're in advance, even if you don't get a notification. I know YouTube's messing with everybody's notifications. I've heard it from more than one person. So if you're having that issue, it's not just you. Hey, let's roll out with another song. How about let's roll out with some Damn It Margaret music. And I'll see you guys tomorrow.
Down and under that, just a twisted pink paper clip, clinging to a head jacket zip. Know that you won't get it a quit. Yeah, know that the hour is drawing near. The case is resting, Sarah Boone should fear. She might soon be shedding actual tears. Down and under that, just a twisted pink paper clip, clinging to a bit of jagged zip, doing nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Leaving you with your lifetime of demise from your sad attempts being the victimized. Know that, yeah, know that. All that you're really gonna see is Prosecutor Jay giving proof to the jury of your murderous pine for commissary. 6-panel conviction arrived at convincingly. Oh, Sarah, can't you tell that your time has come to ring the bell? And let your fans dole you some small slice of hell. The bailiffs will be waiting, cuffs in hand, since you fumbled and flopped all over the stand. So go on, say bye to your circus jaunt. Go on ahead, keep pretending to flit and flaunt. You'll soon be in your brand new prison haunt. Damn it, Margaret. Oh, Sarah, know that now is your time to return to your jailhouse lies. Your face and sob story past its prime. Yeah, know that. All that you're really gonna see is Prosecutor Jay convincing convincing the jury of your murderous and dangerous lies. A sad attempt at trying to be the victimized. No, no, not happening on board DAJ Enterprise. Paper clip, clinging to a bit of jagged zip, which does nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Your angry and controlling attitude won't spare you any grace or fortitude. From the truth, the jury all can see that the time is here, your tops aside, to return to your crummy jail slide. Your face and soft story are past the prime, so go on, say bye, 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 bye to your circus job. Go on ahead and keep pretending to flit and flaunt, because you'll soon be in your brand new prison haunt. Damn it, Margaret. Just a twisted pink paperclip, clinging to a bit of jagged zip. Yeah, know that you won't get an acquit from all your murderous and dangerous lies. Pathetic, you claim to be the real victimized. No, no, not happening on board DAJ Enterprise. Damn it, Margaret.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.